Hello, this is California family law attorney and mediator Brian Ginter. I own and operate the law firm Ginter Family Law and Mediation out of Northern California, although I do mediate over the entire state of California since all of my mediation sessions are virtual. Now, today we'll be talking about a topic that is very near and dear to everyone's heart that is either facing or about to face a family law issue, and that is money. And specifically, we're going to be talking about ways that you can potentially save money, and I'm going to review 5 of those here today. First one is consider going through your dispute in mediation. This is probably the best tip that I can give. Mediation has a lot of potential benefits to it, and one of them, of course, is to keep costs down and to minimize the amount of time spent in your case, which in and of itself helps keep costs down. Mediation is a process where you have a professional, the mediator, who facilitates agreements between people and also handles all of the procedural aspects of the case, such as filing documents, preparing documents, serving documents, and ensuring that people comply with all of the legal requirements that California has. There are other potential benefits as well. One of them is that it fosters communication because there's a concept of mediation confidentiality that applies to the mediation process, such that all of the discussions made in mediation cannot be later disclosed. The second tip we'll talk about today is that if you can't consider mediation as a process and litigation is necessary, then another option could be what I call partial service, or something that is also called unbundled service and limited scope representation. But for all intents and purposes, they all mean the same thing, and I'll just refer to them as partial service. What is partial service? It is when the responsibilities over the case are somehow divided between the client and the attorney. In other words, it's not the attorney that carries all of the responsibilities like he or she would in full service representation. Instead, the attorney only has some responsibilities, and those can be divided up and assigned and allocated a lot of different ways. But one of the most popular ways that it could be done is in a process that I call the hidden attorney. And I have a whole video dedicated on the hidden attorney at our website at ginterfamilylaw.com. If you're thinking about a partial service arrangement, I highly recommend watching that video. But essentially what it is the attorney essentially is doing the drafting of documents and providing legal advice. But the attorney doesn't become your attorney of record, hence the name, the hidden attorney, because people won't know that the attorney is assisting you. If the attorney has limited amount of tasks in the case, then the speed at which you're going to incur those fees and to the extent that you will incur those fees will be kept down. The third tip we'll be talking about today is be proactive in issuing a settlement offer. And this is important because if you wait around to get a settlement offer, either you may never get one, or it may take a long time to get one. By being proactive and initiating your own settlement offer and doing that as early as you can, that will help keep costs down, and it will allow you to put forth a settlement offer on the terms that you feel are in your best interest. Tip number 4, be kind and respectful with communications to the other party. I know this might be a tough pill to swallow, but I strongly suggest doing it. And if you have difficulties in speaking respectfully to the other person over the phone or in person, my suggestion is try to do it over email and maybe have somebody else, including an attorney, review the email before you send it. But there are a lot of benefits in keeping your case and emotions on the down low. First is that angry people have a difficult time focusing on their issues and focusing on settlement. Instead, an angry person is focusing on having a win-lose situation and hurting the other person in the process. And the final tip we'll talk about today is focus on priorities and be flexible on non-priority issues. So the first thing you want to do is figure out what is the most important thing or things to you in your case. In a divorce case, for example, is parenting time your top priority, parenting time with the minor children, or is keeping the family residence a priority, maybe keeping a certain car, or maybe keeping your retirement account. And also think about what the other person's top priorities might be and see if you can't come to a win-win. For the things that are not a priority for you, that's where you want to be flexible and relax your position as much as you can to the point where you feel comfortable, because doing that will build goodwill with the other side, and it will also tend to foster settlement at an earlier stage in your case. That will do it for today's video. If you want to learn more information about mediation or other family law topics or estate planning, you can visit our website at ginterfamilylaw.com, and we have other videos up there that you can browse. You can also feel free to give us a call at the number that's on your screen. Thanks very much and have a great day.